Good day, everyone. We will discuss today Articles 21 to 23 of the revised Penal Code on the subject of penalties. For purposes of our discussion, my reference would be from the Notes and Cases on the revised Penal Code by Leonor de Boado and also by the book of Luis B. Reyes on the revised Penal Code. So let's start the ball rolling. What is a penalty? A penalty is a punishment imposed by the state on a person who commits a crime. Now, a crime can be called an offense if punished by a special law, or a felony if punished under the revised penal code. It is also called an infraction if penalized by a municipal or city ordinance. Now, if you really have to be precise about it, please do not call an offense punished by a special law as a felony, because the term felony is a term exclusive for those crimes punished under the revised penal code. Now, who has the power to prescribe penalties? It is the state through the legislature or Congress. Local government units or LGUs can also do the same through their respective legislative bodies called sanggunians. So those local legislative bodies may enact ordinances which provide for penalties for their violations. What is the purpose of the state in punishing crimes? The first purpose is for prevention and self-defense. That is, to protect society from the wrong inflicted by the criminal. Another is for reformation. That is, to correct or reform or rehabilitate the offender. It can also be for exemplarity. That is, to serve as an example in order to deter or prevent others from committing crimes. The most important purpose is for justice, to vindicate a right violated by the criminal. Now, what are the penalties that may be imposed? This is very important because under Article 21, it states that no felony shall be punishable by any penalty not prescribed by law prior to its commission. This leads us to the criminal law principle of nullum crimen nulla poena sine lege. In English, it means there is no crime when there is no law punishing it. What does this mean? It means that an act or omission, no matter how evil or reprehensible it may be, will not be considered a crime, and henceforth no penalty will be imposed if there is no law punishing the same prior to its commission. Why? Because we abide by the prospectivity rule, and the prospectivity rule mandates that penal laws shall only have prospective application except when it is favorable to the accused. Otherwise, it will violate the rule against ex post facto laws. What is the nature of the penalties in the RPC? First, it is graduated according to severity. We will discuss more of this when we reach Article 70 and Article 71. It is also divided into three periods: a minimum, a medium, and a maximum. except reclusion perpetua, which is the only indivisible penalty left. It is also classified into principal and accessory penalties under Article 25. Penalties are also deemed imposed for the principal offender in consummated crimes. What does this mean? The felonies provided for in Book 2 of the Revised Penal Code have their corresponding penalties. Now, the penalties there are deemed imposed for the principal offender, and they are also deemed imposed in the consummated stage of the felony. The court also cannot increase the penalty no matter how many aggravating circumstances are present, with the exception of qualifying aggravating circumstances. Example number 1, in homicide. Even if there are 5 aggravating circumstances alleged and proven, the penalty can only be increased to the maximum period of reclusion temporal, which is the penalty imposable for the crime of homicide, and cannot be increased to reclusion perpetua. Example number 2, but if the killing is attended by any of the qualifying circumstances in Article 248, which defines and penalizes the crime of murder, it changes the nature of the felony from homicide to murder, which in effect increases the penalty to reclusion perpetua. Do penal laws have retroactive effect? This is answered by Article 22 of the Revised Penal Code. Article 22 states, penal laws shall have a retroactive effect insofar as they favor the persons guilty of a felony, who is not a habitual criminal, as this term is defined in Rule 5 of Article 62 of this code, although at the time of the publication of such laws, a final sentence has been pronounced and the convict is serving the same. Let us dissect this provision. Here, the general rule is that, take note, penal laws shall have prospective application only. The exception is they can have retroactive application if they are favorable to the accused or to the offender, provided that offender is not a habitual delinquent. Therefore, if the accused is a recidivist, a quasi-recidivist, or falls under the circumstance of reiteration, then such offender can still benefit from such retroactive application. What is the effect of a repeal of a penal law? If the repeal is absolute or total, criminal liability under that repealed law is obliterated or erased. This means that the offense no longer exists, and it is as if the person who committed it never did so. Example, X was charged for a violation of a penal law. Subsequently, Congress passed a law repealing the said penal law, with the result that the violation complained of was no longer criminal. The case against X will then have to be dismissed, for a person cannot be prosecuted, convicted, and punished for acts which are no longer criminal. Now, is there an instance, or are there instances where even if a penal law is repealed, criminal liability therein is not erased? The answer is yes, there are several instances. It happens when the repealing law reenacts the provisions of the repealed or former law. It also happens when the repeal is by implication only, meaning there is no provision in the repealing law expressly repealing the former law. It also happens when there is a saving clause in the repealing law that states that the repeal shall have no effect on pending criminal actions. And take note that the repeal of a penal law, which impliedly repealed an old law, revives that old law unless the language of the repealing law provides otherwise. What does this mean? For example, law number 1 was impliedly repealed by law number 2. Take note, the repeal was only implied. Law number 2 in turn was expressly repealed by law number 3. The repeal of law number 2 by law number 3 revives law number 1 unless the language of the repealing law provides otherwise. What is the effect if the private offended party or the victim pardons the offender? The answer is found in Article 23 of the Revised Penal Code. It states, a pardon by the offended party does not, take note, extinguish criminal action except as provided in Article 344 of this code. But civil liability with regard to the interest of the injured party is extinguished by his express waiver. General rule: even if the victim pardons the offender, the fiscal can still prosecute the said offender. Why? Because a pardon made by the victim is not a ground for the dismissal of a criminal case. Reason? It is because a crime is considered as an offense against the state. The victim here is merely considered as a complaining witness. The exception is found in Article 344, which states, Article 344, prosecution of the crimes of adultery, concubinage, seduction, abduction, rape, and acts of lasciviousness. The crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The offended party cannot institute criminal prosecution without including both the guilty parties, if they are both alive, nor in any case if he shall have consented or pardoned the offenders. The offenses of seduction, abduction, rape, or acts of lasciviousness shall not be prosecuted except upon a complaint filed by the offended party or her parents, grandparents, or guardian, nor in any case if the offender has been expressly pardoned by the above-named persons, as the case may be. In cases of seduction, abduction, acts of lasciviousness, and rape, the marriage of the offender with the offended party shall extinguish the criminal action or remit the penalty already imposed upon him. The provisions of this paragraph shall also be applicable to the co-principals, accomplices, and accessories after the fact of the above-mentioned crimes. Now, you will notice that in the third paragraph of this article, I put an asterisk before the word rape because, as I will explain later, rape is no longer considered as a crime against chastity. Before the enactment of Republic Act 8353, which amended the felony of rape in the revised penal code, rape was categorized or classified as one of the crimes against chastity, including seduction, abduction, and acts of lasciviousness. These are crimes grouped under one classification, but rape now is already considered as a crime against persons. Let us dissect Article 344. Okay. Take note that in crimes of adultery and concubinage, only the offended spouse can file the complaint. Now, if the offended spouse does not want to or refuses to do so, then no other person can file the complaint in his or her behalf. If the offended spouse decides to file a complaint, he or she must include both the offending spouse and his or her mistress or paramour. So, the offended spouse cannot choose. He or she cannot say, I will just file a case against the mistress or the paramour, and I will spare my husband or my wife. No, the offended spouse cannot do that. To repeat, he or she must include both the offending spouse and his or her mistress or paramour. However, take note, if the offended spouse has consented to or pardoned the offenders, then he or she can no longer file a case. The pardon here can be implied as when the offended spouse in adultery engages in sexual intercourse with the offending spouse subsequent to the adulterous conduct, or it could be that the husband did nothing to assert his rights as such husband. But the pardon, whether expressed or implied, in adultery or concubinage must come before the institution of the criminal action, and both offenders must be pardoned by the offended spouse for said pardon, or in order for the said pardon to be effective. Now, when you say institution of criminal action, it means the complaint has been filed with the court, not with the fiscal. Now, in crimes of seduction, abduction, or acts of lasciviousness, it shall not be prosecuted except upon a complaint filed by the victim or by her parents, grandparents, or guardian in the order mentioned. What does this mean? Let us look at these various scenarios. Scenario number 1. X, who is of legal age and is in complete possession of mental faculties, refuses to file a complaint against the offender. What happens, or what is the effect? His or her parents, grandparents, or guardian cannot file the complaint. Scenario number 2. X, a minor, files a complaint against the offender. Can his or her grandparents or guardian prevent him, the minor, from doing so? No. Minors, in offenses of seduction, abduction, and acts of lasciviousness, which are crimes against chastity, can decide independently of their parents. Scenario number 3. X here, who is a minor, refuses to file the complaint. So, it is the opposite of scenario number 2. Can X's parents or grandparents or guardian in the order mentioned override the decision of the minor? The answer is yes. His or her parents, grandparents, or guardian can file the complaint. Now, if the parents refuse to file a complaint, then the grandparents may do so, and so on and so forth. If the grandparents refuse to file a complaint, then the guardian may file the complaint. Scenario number 4. If X happens to be an incompetent, or if X is insane or mentally disabled, regardless of age, then his or her parents, grandparents, or guardian may file the complaint in X's behalf. Scenario number 5. What if the father refuses to file the complaint? Can the mother do so? Yes. And in the case of grandparents of either side, there is no preference, no? So what does this mean? Either the maternal grandparents of the minor or of the victim or the paternal grandparents of the victim may do so, may file the complaint, provided the parents refuse to do so. Now, in the case of a guardian, it is enough that he or she affirms under oath that he or she is the guardian. Otherwise, if the minor denies such guardianship, then the guardian must prove the same by means of judicial order. So he must present a judicial order showing that he was appointed as the legal guardian of the offended minor. No criminal action can also be instituted if the victim or her parents, grandparents, or guardian in the order mentioned has expressly pardoned the offender. Okay? I'm still talking about the offenses of abduction, seduction, and acts of lasciviousness. No, they are crimes against chastity. So, if the victim doesn't want to file a complaint against the offender, if the parents don't want to file a complaint against the offender, the grandparents or guardian, both of them also don't want to file a complaint against the offender, then nobody can file the complaint. Not even the police, not even the person who has personal knowledge of the crime. Why? Because they are crimes against chastity. The crime concerned is considered as a private crime. So beyond the guardian, no other person can file the complaint. And take note that such express pardon must be made before the institution of the criminal action. So to repeat, before the case is filed in court. So, question, if the complaint has been filed with the fiscal's office, can the offended party or her parents or grandparents or guardian still pardon the offender? Yes, because it is still at the prosecutor's level. No criminal action has been instituted yet technically, because as already explained, the phrase institution of criminal action means that the complaint is filed with the court and not with the fiscal. Scenario number 1. X, who is of legal age and is in complete possession of mental faculties, pardons the offender. What happens here is his or her parents, grandparents, or guardian can no longer file the complaint. Scenario number 2. If X, who is a minor, pardons the offender, this time, the pardon needs the concurrence of the parents, grandparents, or guardian in the order mentioned. Scenario number 3. X, who is a minor, refuses to pardon the offender. Can the parents, grandparents, or guardian pardon the offender on behalf of the minor? The answer is no. They cannot override her refusal to pardon the offender. Scenario number 4. If X is an incompetent or insane or mentally disabled, regardless of age, his or her parents, grandparents, or guardian, as the case may be, or in the order mentioned, may this time pardon the offender. What is the underlying reason why in crimes against chastity, they cannot be prosecuted de officio? cannot be prosecuted de officio means it cannot be filed in court without the complaint of the victim. Reason? It is out of consideration for the victim and his or her family who might prefer to suffer the outrage in silence rather than go through with the scandal of a public trial. Take note that the enumeration in Article 344 is exclusive. This means that only the victim, parents, grandparents, or guardian in the order mentioned can file the complaint or expressly pardon the offender. Now, before proceeding, let me remind you that in the crimes of adultery and concubinage, the pardon may be expressed or implied. But in the crimes of abduction, seduction, and acts of lasciviousness, the pardon here must be expressed. Implied pardon is not allowed. But in both instances, whether for adultery, concubinage, abduction, seduction, and acts of lasciviousness, the pardon, if in case a pardon is made, it must be made prior to the institution of the criminal action. Is rape still considered a crime against chastity, considering that it is mentioned in Article 344 in its third paragraph? The answer is no. Rape is no longer considered a crime against chastity, for it is now reclassified as a crime against persons pursuant to RA 8353, the law that amended the felony of rape in the revised penal code. It is no longer considered a private crime, which means that it can now be prosecuted even without a complaint filed by the victim. Hence, pardon by the victim of the offender in the crime of rape will not extinguish the offender's criminal liability. What is the effect if the offender subsequently marries the victim of seduction, abduction, acts of lasciviousness, and rape? The effect is it extinguishes the criminal action or remits the penalty already imposed. For example, Y rapes X. X files a complaint against Y in the fiscal's office. Thereafter, X marries Y. By reason of such marriage, the complaint will be dismissed, or if the fiscal has already filed a case in court, the same will also be dismissed, or if Y has been convicted and has started to serve sentence, he will be released. This also benefits the co-principals of Y, the accomplices of Y, and the accessories of Y to the said crimes, except in rape. Take note. So, if Y has a co-principal, or he has an accomplice, or he has an accessory to the said crimes, particularly seduction, abduction, and acts of lasciviousness, this co-principal, this accomplice, or this accessory will benefit from such marriage of the offended party with the offender, except in rape. So in rape, the co-principal in rape, the accomplice in rape, or the accessory in rape will not be benefited. If the victim in rape merely pardons the offender but does not marry him, it will not extinguish the criminal action nor remit the penalty already imposed. This is an important point because unlike in the crimes of abduction, seduction, and acts of lasciviousness, the mere pardon by the offended party will already extinguish the criminal action. But in rape, it will not. The only way for the criminal action to be extinguished or for the penalty already imposed to be remitted is by virtue of the marriage between the offender and the victim, meaning whether prior to the institution of the criminal action or whether during the pendency of the criminal case or whether during the time when the convict in rape has already started to serve sentence, they happen to marry each other, then such pardon will extinguish the criminal action or remit the penalty already imposed. Let us go to another topic or to another question with respect to the civil liability. Can the civil liability or the payment of damages of the offender be waived by the victim or be the subject of compromise? The answer is yes, because payment of civil liability or payment of damages is civil in nature and the state has no right to insist in its payment. In other words, the victim and the offender may settle the civil aspect of the case. Like for example, if the victim has filed a case for reckless imprudence resulting in physical injuries, the state cannot prevent the victim and the offender if the victim agrees to settle the financial liabilities of the accused. Meaning to say, the accused will pay for the hospital or medical expenses of the victim and other monetary obligations like loss of income and other money matters concerning or in relation to the case.